a fellowship program to allow academics and researchers and practitioners to focus on democracy and rule of law in the EU. So I know we're not that many in the audience. I think that's also because we opened up an online registration where people can join online and see it. So that's, the point that this is live streamed. And we also have Norma in the back who, hello, Norma, it's nice to have you here, who will be doing a graphic recording of the discussion and showcase the topics and maybe the difficulties and the challenge of rule of law in the EU at the moment. So on the topic, I know most of you know that the Rule of Law report was published in mid-July. I personally was on holiday, so I did not have the chance to read it straight away, but we still thought it would be extremely important to have an event about it to discuss the results. Also because for the first time, so I think this was the third Rule of Law report that existed from the European Commission, it's the first time that there were country-specific recommendations added. So it's not only descriptive, but also something where you had recommendations. And of course, our discussion is very timely because last Sunday you had the decision, or rather the proposal of the European Commission on the funding cuts from 3 cohesion programs in the framework of the Conditionality Mechanism against Hungary. I'm sure you followed as well. I know this is not exactly the topic of our discussion, but the preventive and the punitive arms should be part of the discussion and should be seen together. So without further ado, I will present our speakers. I'm very happy that they were able to join. We first have Nicolaas here, who is Deputy Head of Unit for the Fundamental Rights and Rule of Law at DG Just of the European Commission. Then we have Ralf Kett, who is Head of Unit for Justice and Home Affairs in the General Secretariat of the Council of the EU, and Anna, who I mentioned briefly, who is a Constitution Fellow and Assistant Professors at the Institute of Legal Studies of the Polish Academy of Science in Warsaw. Unfortunately, an MEP was asked but could not join us today, so the Parliament is not represented, but I hope that with the Council and the Commission, plus an academic, being an expert on rule of law, we have a few sides covered on the topic of rule of law. And I'll start with you, Mr. Bell, because obviously you're a representative of the Commission here today, how you assess the current state of the rule of law in the EU, based on the results, of course, of the report that you published mid-July.
Thank you very much, and thank you for organizing this discussion today on the 2022 Rule of Law report, and also for inviting the Commission, of course. I would like to give a brief introduction, if you don't mind, to set the scene a little bit. And to start with confirming that promoting and protecting the rule of law in the EU remains very high on the Commission's agenda. Unfortunately, over the past years, we have seen rule of law concerns emerging and deepening in a number of member states. And during these last years, the Commission has gradually developed and used a variety of tools and instruments to address these challenges. Some of these tools focus on promotion of the rule of law. Some are aimed at prevention of rule of law problems, and some are there to provide an effective response when breaches of the rule of law materialize and promotion or prevention have proven insufficient. 2 years ago, a new tool was added to this toolbox, the European Rule of Law Mechanism, with at its center the Rule of Law report. And in July, the Commission adopted the 3rd edition of this report. This 2022 report further develops and deepens the exercise we started with the first editions. It is primarily aimed at preventing challenges from emerging or deepening. In particular, it assures the follow-up to the challenges we identified in the previous reports, examine the extent to which concerns have been effectively addressed or persist, and whether the situation has improved or further deteriorated. Presents both positive and negative developments across the 27 member states in 4 key areas: the justice system, the anti-corruption framework, media pluralism, and finally, institutional issues related to checks and balances. For the first time, as you said, the report this year contains specific recommendations to all member states, and this has to be seen as a natural evolution of the clear assessments we already made in the previous editions of the report. And what we do is we try to continuously seek to improve the report as we go. This year we have conducted more than 500 virtual meetings with stakeholders in order to get information on the developments on the ground in the member states, including, of course, civil society organizations. And just to highlight that civil society organizations are very important partners for the Commission in preparing the report because they provide indispensable information on the situation on the ground. Also, one of the objectives of the report is to serve as a basis for an informed discussion in general. In the Council earlier this week, there was a general and I think very constructive discussion on the situation of the rule of law based on the 2022 rule of law report. And I'm sure that Ralph will say more about this in his intervention. Later in November, we will have in the Council a specific discussion on the rule of law situation in 5 member states. Every half year, 5 member states are specifically examined in the Council. In the European Parliament, we also have discussions on the report in national parliaments as well. And today we're having the discussion amongst ourselves here. And all these discussions are valuable and important. Promote a rule of law culture, that is the objective. And without a report that can serve as a basis for the discussion, these exchanges would be very difficult to have. But, and I'm concluding, unfortunately, we see that promotion and prevention efforts are not always sufficient. And the Commission is fully aware of this as the guardian of the treaties, and therefore is determined to use all the tools at its disposal to uphold and enforce the rule of law where this is necessary, through infringement proceedings, the Article 7 procedure that are pending, the conditionality regulation that was already mentioned, but also the European semester and the recovery and resilience plans that are being adopted by member states. But this is not the specific topic of today, so I will not go too much into detail and would leave it at this for my introduction. Thank you.
Thank you very much for the introduction and for setting the scene. I would go to the Council next, to Mr. Kaessner. Of course, the rule of law report is the preventive arm. Knowing the reality on the ground, I think a lot of focus has been on, of course, the sanction mechanisms, as we are in a situation where we have a few countries that clearly do not respect basic principles of rule of law. So my question to you would be, what is the Council view on this rule of law report, of course, but also do you think that there is maybe a tendency to, kick the can down the road a little bit from one member state to the other, knowing that there is also a dialogue happening at the Council and at member state level on the rule of law issue?
Thank you, Sophie, and welcome everybody. First, a little disclaimer, I'm working at the Council, I accompany the work of governments, but I can't speak on behalf of the Council, of course. I'm just from the General Secretariat, so we can't speak on behalf of the Presidency or the Council. But I'm more than happy to share my personal views with you. And yes, so this week, ministers have for the third time a kind of general discussion on the basis of this rule of law report that the Commission prepares. I think this has developed quite well over if you look at let's say 4 years ago, and now you see that there's a really good basis for discussions about the situation in the Union across the board. Not only at general level, so where do we stand in the Union, also this country-specific element, which is now happening twice a year. So 10 member states every year are being discussed on the basis of, again, the Commission report. And this, again, was taken up compared to the beginning. We see that also the member states that have been quite cautious at the beginning are now feeling that this is adding value to participate, and that it makes a big difference in the Union. Sitting around the table, it's not easy to bring let's say to bring this whole topic into the Union agenda, but it works, and this here's the recommendations in the report were taken up. Vast majority of them. This is a good thing. It helps them to focus their work and the discussions with the Commission. I don't think we will end up in the Council and checking now every year boxes and who has done what. This is far more a kind of roadmap for each bilateral state. Really a vast majority of them. And I think also the scope of the report a little bit also, yes, to public media also good, and trickles down into more concrete discussions like in the European Media and Freedom Act that we will launch soon. So I think in summary, I would just say that it has moved very well into the right direction, and that you sense that all member states are considering this one of the top political issues of the Union, also due to its possible future accession, the foreign policy credibility, the internal market, the justice area. It has now come, everybody has understood how essential this is. And I think the momentum is clearly there. This is there to stay. It will not easily be, let's say, downgraded again. I'd rather see that it's there to stay. It's one of the new policies of the Union, and still has potential to develop, I would say, of course. But overall, it's one of the rather good stories of the Union. Yes. Thank you.
Thank you. I'm sure Anna might disagree, or we'll see. But maybe from your side, Anna, working as an academic in Poland, what was your view when you read the rule of law report of the current situation we're in at the moment, and also the EU's response to it?
So first and foremost, I would say that this is an important part of the rule of law toolbox that consists of the mechanism that my predecessors described, and the part that actually brings together all the areas that are understood under the rule of law principle, which are not only judicial independence, but also corruption, anti-corruption framework, checks and balances, and media freedom and pluralism. And this is really good because this broad framework allows for discussing new elements and new dangers to the rule of law, democracy, and human rights that sadly have not ceased to appear in member states. And I'm particularly focused on two usual culprits, Hungary and Poland. And actually, as you may know, the reports were in fact created in response to ongoing crisis of the rule of law in those countries. And they were created to somehow to somehow answer the argument of those governments that only the two new member states of the Union, not so new, I mean, joined 15 years ago, more than 15 years ago, 18 actually, would be scrutinized by more established and more powerful member states. So in this respect, from the viewpoint of people who work on the ground to prevent further deterioration of the rule of law, it is useful because it took away an argument from governments that they are being unjustly targeted. And then it's another forum, a very regular forum of discussing and evaluating the developments that happened in the past year. And I would congratulate on this initiative. And I feel that in the past 2 years, it has improved a lot. In the first year's reports, I would see that there was an imbalance, and perhaps it was related to the input of civil society organizations. So I thought that, for instance, in the Polish report, the judicial independence section was very well prepared. And other sections, for instance, media freedom and pluralism, they were more focused on, I would say, more formal guarantees to media freedom and pluralism that exist in most countries in the EU. But it was not focused on, I would say, lived reality or informal power or actual personal changes that has been happening that actually impact on the scope of media freedom and pluralism. And this is the area that can be further improved to not focus so much on whether there are specific laws that introduce guarantees to this or that, but how they are actually implemented, or whether there are independent courts and institutions that can monitor their implementation. And another thing is that the rule of law reports should be discussed also during other procedures, such as Article 7 procedure that was launched against Poland and Hungary in 2018. And actually, among people who are engaged in this rule of law promotion on the ground, there was a bit of a disappointment that the hearings regarding Poland and Hungary has been stopped during the pandemic, and that they were not held on a regular basis. So in this context, these reports were another opportunity to have more structured and regular discussions. But of course, the problem with the reports is that they have no enforcement mechanism, and that they should be the basis for other actions, for actions of and if using of other elements of the toolbox. And actually, in the past years, I would say that the most effective element of the toolbox that was used to contain judicial independence decline was actually infringement actions to the ECJ. So the Polish civil society is looking forward to even more EU law infringement actions and cases brought at ECJ. If the Commission can proceed, that would be really welcomed. And on the other hand, we have been observing that the EU institutions have developed a differentiated approach to various areas of the rule of law. So, for instance, regarding judicial independence, they use rather infringement actions, whereas what concerns media freedom and pluralism, a lot of attention is paid to new legislation, Media Freedom Act, Anti-SLAPP Directive, and with regards to anti-corruption framework, there are those new mechanisms such as conditionality regulation, and also very powerful leverage that is approval or not approval of national recovery plans. And I will stop here, and maybe we can discuss it further.
Yes. You mentioned two things that I'd like to go back to in the report, which is a question straight to Mr. Bell. Two questions at once. The first one is that there are certain areas that the report focuses on, so anti-corruption framework, judicial independence, institutional questions, and media pluralism. Working on civil society myself, for instance, many have said that there is a lacking aspect of civil society. So the question is whether there is the plan to make it even more comprehensive and to showcase more the systematic aspect of rule of law breaches. And the second question is also whether, now that we do have the very welcome change that we have country-specific recommendations, whether next time there will be also, for instance, milestones and benchmarks on, the enforcement part, because my feeling is that it is great to see that the EU is moving forward in these aspects, but that especially on enforcement, and also taking from the discussion we had this morning on corruption, that on the enforcement part it is more difficult, and this might be also an aspect that maybe could be part of the rule of law reports.
Yeah, just to comment on the role of civil society and also the attention given to the situation of civil society in the report. I think, as I said in my introduction, it is very important for the Commission to closely involve civil society in the preparation of the report. This is what we have been trying to do from the beginning, and I think that in the course of the 3 years, we have managed to establish an improved cooperation with civil society organizations to ensure that civil society understands what we are trying to achieve with the rule of law report, to understand how best they can effectively contribute to the preparation, and on the side of the Commission, allow for, let's say, better conditions and timeframes within which involvement of civil society organizations in the preparation of the report can be ensured. Just to mention that for the preparation of the report every year, we publish a stakeholder consultation online with detailed questions, which are addressed to member states, but at the same time also to stakeholders. And in fine-tuning the questionnaire, we see that the contributions are richer and richer. I think we received over 200 written contributions for the 22 report. As I said, we have, in addition to the written input, virtual meetings with stakeholders, more than 500 this year. So this is what we try to do to ensure a good involvement of civil society in the preparation of the report. Also, content-wise, in the report, we try to give visibility to more visibility to the situation of civil society from a rule of law perspective. So, what is the general framework in which civil society operates in a member state? Is there support also in terms of funding arrangement, but also is there sufficient space for engagement of civil society in the public discourse? And sometimes even is civil society not in one way or the other under attack by government or government-friendly instances? So these aspects of the role of civil society as an essential check and balance in the overall system of rule of law is given this specific attention in the fourth pillar of the rule of law report. That as regards the involvement of civil society, there was also a reference to the link between the content of the report and so what, enforcement action where necessary. Before talking about enforcement action, I would just like to say that the rule of law report is more than a basis for enforcement action. I think the rule of law report is not only relevant for those member states where there are serious rule of law concerns, it is relevant for all 27 member states. Everybody has reason to look carefully at the situation of the rule of law in its own member state. Every member state has reason to look for improvements of the situation, to prevent possible challenges from emerging. And the rule of law report is also a source of, let's say, good practices, which can inspire member states who see that they are confronted with similar problems as in another member state to look at solutions or approaches developed in one or the other member state. And that is actually a very positive and constructive dimension of the rule of law report and of the discussions that are taking place on that basis. I just witnessed what is happening in the member states where I come from, the Netherlands, where the country chapter on the Netherlands is taken very seriously by the authorities, where the government prepares an opinion on the rule of law report, which is submitted to Parliament for a debate, just to make clear how member states can make use of the report to actually ensure that it permeates in all levels of the member state concerned. Then it is true that there are member states where there are serious rule of law concerns. They are mapped in detail in the rule of law report, and that is already relevant in itself. But I think it is important in our approach to see that the rule of law report and the enforcement actions are separate instruments of our rule of law toolbox. Every instrument and tool of the toolbox has its own rationale, its own logic, and its own requirements for its application. Of course, what is very important is that there is coherence among the different tools and instruments, but let's say automatic consequences from findings in the rule of law report for application of other instruments, that is not part of, let's say, the architecture that we have conceived. Every instrument has its own rationale, its own logic, and its own conditions for its application.
Thank you. I'd like to come to Mr. Kaessner again to maybe discuss the conditionality mechanism, because we had that proposal on Sunday by the Commission, and now it will be discussed in the Council. So maybe if you can give us, the next steps of what is going to happen on that issue in particular. I mean, it has been discussed a lot in the media, and I think it's worth discussing here as well, just to understand what the next steps are and what it could mean for the future, knowing that, of course, the decision is still up on the resilience and recovery facility, or the other way around. So at least the recovery funds and on the EU 3 cohesion funds that where 65% have been cut. Of course, 65% only of these 3 programs, which, by the way, is less when you count the total money that Hungary receives.
Yes, just briefly, of course, we see at the moment that the whole struggle around values, rule of law, moves a little bit to the budget area. That is, I think the ground has been prepared. We have, I think, a very important court judgment from the spring that opens up quite some new perspectives in terms of how the Union can protect its values. And we now see this, sort of say, in action. And the conditionality regulation is a good example of where the Union now tries to use kind of the budgetary track to enforce a rule of law as a value, as a fundamental value of the Union, certainly. So the Commission proposal has just been issued. The presidency is now thinking about how to take this through the council. There's of course some high deadlines. It will be handled in the budgetary filière, if you want. So with the economic and finance ministers ultimately taking a decision. And let's say that now we will have to see how this plays out now. Yeah, it's the first time that this submitted to the ministers. There have been some intensive negotiations between the Commission and Hungary in the run-up. No member state really had a good look at that, or could, because this was a kind of bilateral negotiation. And now the member states receive this proposal and will take a good look. Given that here, of course, the majorities are different than in for instance, the Article 7 procedure. So this might also make it easier to take a decision in this field. On the substance itself, I think their member states will. Well, it's almost impossible in this short amount of time for member states now to restart digging deep into the details of the assessment that the Commission has made. And so probably the discussion in the Council cannot be as detailed as what the Commission has done in the run-up to this proposal. And I would say let's see now how this will be taken forward in the working party and then in the ministerial debate for the ECOFIN Council. But on the substance itself, only to say that that is the real battleground at the moment. I think this fall, this will be more the battleground than the Article 7 procedures or this rule of law mechanism that is constantly moving anyway. Yeah, this is a given. It's a kind of a fundamental structure working anyway.
Thank you. Whether it moves forward quickly enough, that's another question, but I'm sure it will come as the questions. One question to you, Anna, which we haven't mentioned yet, is you're living in Poland, and of course, with the war in Ukraine, there's been a lot of refugees coming to Poland, but also we could see that there has been a political shift between how Hungary and Poland especially are regarded. So maybe if you want to comment on that in particular and what effect it has from your view, so what the Russian aggression war in Ukraine had as an effect on the rule of law portfolio, but also generally how the EU has moved towards Hungary and Poland.
So before the debate, we've been briefly discussing that actually since a couple of years, the EU has an approach for Poland and an approach for Hungary. So there is no one approach that fits all, but it has been really in stark contrast this year, in the past 6 months, how the rule of law in Poland and the rule of law in Hungary problems are being treated and discussed in the EU institutions. And at one point, there was a fear that among civil society in Poland, this pro-democratic civil society, that due to civil society's generous welcome to refugees from Ukraine, that the Polish government has taken a great credit for and a great political benefit, that this will somehow be a factor that overshadows the rule of law concerns, judicial independence concerns, etc. And actually, since the war started, these concerns have not gone away. There have been many alarming developments, and we must remember that Poland, for the Polish government, Polish authorities are not respecting, not implementing the judgments of the European Court of Justice. And since actually 4 years already, we've been discussing a growing case law of the ECJ, but also since 2020, a growing and very important case law of European Court of Human Rights. And this case law is the basis right now for very concrete recommendations, and it should be the basis of the milestones that are negotiated with the Polish and Hungarian governments regarding the rule of law commitments that are necessary to disburse money from the post-pandemic recovery fund, the Next Generation EU. So there was, I think, a lot of tension around the decision of Ursula von der Leyen to come to Warsaw in June and to shake hands with Prime Minister Morawiecki to a great fanfare and celebrate the fact that they've agreed on the milestones. And the fear was that the milestones themselves in the Polish National Recovery Plan are actually not meeting the requirements from the ECJ and ECTHR case law. And that was a really big issue, and the topic is still really important. And last month, we've seen that 4 judicial associations, European associations of judges, have launched a case against EU institutions, actually against the Council, for approving the milestones that were negotiated by the Commission. And at the same time, there have been more interest to use conditionality regulation that is in force since January of this year against Viktor Orban's government in Hungary. And there's been even more attention ever since Orban won elections in April with a landslide victory. So so there is also this element that the EU in the past tended to see Poland and Hungary as countries to which perhaps similar tools may be applied. And this year, we see that it's increasingly using different options at the table.
Thank you very much. I think that was an important point. I'd like to open the floor. We're not that many, but if you have your question, it's your moment to raise your hand and quickly present. And I'm in particular looking also at the reconstitutions, where they have comments. So please don't hesitate to come in. Yes, Clara. Yes. Okay. That would be great.
Is to let them ask questions.
Yes, that would be great.
Okay.
Yeah, go ahead.
Thank you. I'm speaking on behalf of Esther Fay from the European Parliament, and she asked, and I guess that question is directed to a representative of the Commission, but probably the opinions of the other participants would also be super interesting. So our question is, do you think the academic freedom is an issue to assess in the framework of the Rule of Law report? And if yes, would you consider to do it in the next report? And if so, how? One question.
Yeah, can we maybe take some more? 2 questions and then, yeah. So if you want to, Clara, if you want to say the 2 other questions, so we can take 3 and then I'll give it back to the floor. That would be good.
Or maybe questions from
sorry. It's 2 things at once, huh? It's hard to coordinate. Andy, please go ahead. All right, thank you. Is there another question from the room? No? Do we have another one from the online audience? Yeah, maybe we'll start with the first one. I think the 2 ones are directed at you, Mr. Bell, on academic freedom and corruption.
Yeah, to start with the question on corruption, I think corruption is one of the 4 pillars of the report. So it is clearly acknowledged that the anti-corruption framework is an essential component of our rule of law assessment in the report. That will not change. We want to maintain this structure to be able to show developments over time. At the same time, we try to improve the report year by year in respect of all the pillars. This relates to the manner in which we collect information from stakeholders, including civil society organizations. And we are also very interested to listen to feedback from stakeholders on the report. What is missing? What could be further developed in next year's edition? And in this way, in a sort of iterative process, we try to improve the, let's say, increase the depth of the assessment across all 4 pillars and improve the quality at the same time. So it's an affirmative answer to your question. On the issue of academic freedom, that is obviously a very important topic, which is also followed by the Commission. What is important to recall is that the rule of law report is one element of a broader endeavor at EU level to strengthen the values of democracy, equality, and respect for fundamental rights. It is focused on the rule of law, but on the justice system, on the checks and balances, but it also has a pillar on media pluralism, goes into anti-corruption. But next to the rule of law report, we have other endeavors the Commission is working on. We have, for example, the strategy for the implementation of the Charter of Fundamental Rights. We have the European Democracy Action Plan that was already mentioned. And these initiatives are specifically focused on also contributing to upholding fundamental rights. This year, the Commission publishes an annual report on the application of the Charter. As an example of the initiatives the Commission is undertaken in addition to the rule of law report. But for now, the focus of the rule of law report will be on the 4 pillars that we have been discussing so far. And by maintaining this structure, we also allow to see the developments over the years. Of course, rule of law is important as such for the effective protection of fundamental rights. And in that respect, there is a direct relationship between rule of law and fundamental rights.
Thank you. Are there any more questions from the audience? Yes, 2. So please go ahead. I'll start with the one behind and then in the front. Yeah, that's you.
The deadlines were pretty short for the public consultation, published just before Christmas, ending just in January. We all know that December is a little bit slow here in Brussels. So I was wondering if this time we will have longer timeframes potentially for the next report. In general, if you could walk me through what's foreseen for 2023 to kind of circumvent this issue this time.
Thank you. I'll take one. Yeah. Yeah, sorry.
And people online can hear as well. Thank you.
Hello, my name is Christina Wójcik, working, I have the same name as you, actually, Anna. I'm working for the representation of North Rhine-Westphalia here in Brussels. I have actually two questions. Perhaps the first concerning you, Anna, and Nicolaas as well, concerning Poland. Because I think right now, the focus is a bit more on Hungary, but I was wondering what is actually now happening concerning the law concerning the new disciplinary chamber. Is this enough for the Commission? Because no, obviously the press recently said, no, the Commission thinks it's not enough to meet the milestones in the Polish recovery plan. So what is the way ahead? Is the Polish government moving on this matter or not? My second question addresses perhaps you, Mr. Kaessner, concerning Hungary. Because we know the time frame in the council is either 1 or 3 months probably. How can the council consider also the deadline for the concerning the implementation of the legislative measures? Because I cannot really imagine how this can work, that the Hungarian government can within 3 months implement all the measures of law situation in Hungary or not. Thank you.
Thank you. I'm not sure if we have any other questions from the audience. Yes, a third one, perfect.
So, hello, my name is Edita Tutalore. I am from the UN Human Rights Office, based in Brussels. And we really welcome recommendation in the last report. And I would like to beat a little bit on the question, so on the previous question concerning the plans already for the next 2023. And because one of so how are you going to address the recommendations? Do you envisage any kind of assessment of the recommendation? And also like from our perspective, from the UN system, because also so we have the system of recommendations, etc. And the next report to some extent should address the implementation of the recommendation. But in our case, it is so the approximately 4 years, and you have only, I think, so taking into account that also you need time for drafting, etc., less than 1 year for assessment, and some of recommendations already I think so also needs more time to be implemented. That's why also so what is your take on that? Thank you very much.
Thank you. I think we have 4 questions in total. And if that's okay, I'll start with you again, Mr. Bell. I think especially the question on the feedback from stakeholders and also the question on the recommendations of the report.
Yes, thank you for this question. We have duly noted, let's say, the challenges on the timing. Of course, it is an annual report, so we intend to publish the next edition of the report again before the summer. So we have to sort of fit in the entire process within this, let's say, fixed amount of months. We're at this moment assessing how we can accommodate or adapt the, let's say, the timing of the different steps towards of the preparation towards the final report. And indeed, what we try to do is create more time for stakeholders to provide their input. But it has not been, the puzzle has not been finalized yet, but perhaps we could advance a little bit the launching of the consultation, for example. But we are conscious of the let's say the challenge that you raise, and we try to accommodate it in the limits that the annual exercise puts to us. The question on the follow-up to the recommendations. So our idea is to follow up on the recommendations both at the political level and at technical levels in discussions with member states on how they look at the recommendations, what they intend, what they are considering as possible follow-up, whether they are looking for some guidance on how this could be done. So we intend to follow up, and it's what we're already doing at a political level and at technical level, with the objective to assist member states in the implementation of the recommendation. And that is a process which has already started. At the same time, in next year's report, we will, of course, analyze how the recommendations have been implemented. And that will be featuring in next year's report as well, as part of the country chapters. So yeah, that is what I can say at this stage.
Yeah, I'll go to Anna if you want to respond to the Polish question in particular on the new law for the disciplinary chamber. Now I got it.
Right. So there were essentially 3 milestones. One concerned implementation of the judgments of ECJ and ECTHR as well. The second one on the disciplinary chamber, and the third one on reinstating the judges that were illegally suspended. So the Polish government has not fully met any of those milestones. The law on the Supreme Court was changed. The draft law presented by the President of Poland was actually passed. But after the initial reactions, positive reactions to this step, after pressure from EU Commissioners Jourova, Reinders, and Timmermans, there was an official announcement by President of the European Commission that this law is not meeting their requirements. And that is indeed the case, because the new chamber was created. The chamber has a different name, not disciplinary chamber, but the chamber of professional responsibility. And it was created but vacant because there were no judges selected to it. So for a couple of months, the disciplinary system worked with interim judges. And then the President of Poland selected 11 people from the pool of 33 names that were drafted by lots by the President of the Supreme Court. And the President of Poland confirmed his selection last Saturday, actually. And unfortunately, he chose people who are legal judges of the Supreme Court, but also those who, under the current case law of ECJ and ECTHR, are not meeting the requirement of judicial independence, which means that they cannot create a panel of judges that would be considered an independent court in the meaning of EU law and European Convention on Human Rights. And actually, on Monday, European Court of Human Rights confirmed that this new chamber is not legal, because it issued interim orders in the cases of 5 judges who will have their cases heard before this new chamber. So this is something that the EU institutions cannot overlook, because there is already a decision of the European Court of Human Rights.
Thank you. Also not present here, but I think the European Court of Justice and the European Court of Human Rights have been working a lot on infringement procedures and others to showcase also the rule of law violation. Yeah, just a second. I'm going to go to Mr. Kaessner first with a question on Hungary we had concerning the conditionality mechanism. And I would like to maybe add a point here, and it's a very open question on whether the council, and I know you work for the Secretariat and obviously not the permanent representations, but whether there is a general feeling that the Orban government has good intentions in actually carrying through the reforms that were presented.
I take the first question first. It's easy. So
I know, Mr. Bell, you wanted to. Yeah.
That's of course, 27 comments around discussing what constantly. The government is acting in good faith. That is the foundation of business of the union and how the union makes decisions and what in good faith when they will also implement it. And but Hungary is an example of how this is you can that
Thank you. I take from this that the Council is putting rule of law on the negotiating table as much as every other policy field, but maybe I got you wrong. Good, thank you. It's fair to say it.
Yeah, this also fundamental rights are not a purely legal area. For instance, it's, of course, you look at the U.S. Supreme Court, what the U.S. Supreme Court has done. Of course, even judges change their mind. Then it would be it's perhaps not. Yeah, I'm talking.
I know that you, Mr. Bell, wanted to say something about Poland, maybe, and then I had to cut. But please go ahead and say whatever you wanted to say.
Yeah, no, I think just to react. So, of course, there's politics, and there's law, and I think okay, these are different things, and politics cannot set aside the law. Not in a community which is based on the law, such as our union. But I think on this we all agree. I just wanted to make one point on the Polish situation, the Polish recovery and resilience plan. That plan has been approved by the Council. There are milestones, like in any other recovery and resilience plan, included in the Polish plan, and some of these milestones relate to judicial independence in order to address a country-specific recommendation under the European semester. Now, these are important milestones. They do not solve everything, but they are important and they need to be implemented correctly. They need to be implemented correctly before funds can be disbursed. And just to make the point that the assessment as to whether the milestones of the Polish plan have been fully implemented and correctly implemented is an assessment that will be done by the Commission at the time of the first payment request that will be made by Poland. And so far we have not received such a payment request. So there is no formal assessment of how the milestones have been implemented. And that is something that is still to come once this payment request is made. Also wanted to add something on implementation of rulings of the Court of Justice and what the Commission is doing about that. I think about the situation in Poland, I think it is good to recall that on the 14th of July last year, there was an order for interim measures issued by the Vice President of the Court of Justice, imposing a daily penalty payment of €1 million per day for as long as Poland has not fully implemented a number of requirements directly related to protect the protection of judicial independence. And the Commission is sending calls for payment to Poland since the end of November, when this order was actually, this daily penalty payment was imposed, until the day of today, and it will continue to do so until the interim measures order will be fully implemented. So this has to be, we're talking about more than €300 million due already as we speak. And of course, this has to be seen in the total picture of what is being done also by the Commission in terms of enforcing rulings of the Court of Justice in the area of judicial independence in Poland. And I just wanted to clarify that for the record.
No, thank you. I think it's very important also because it's a lot of processes, and sometimes it's good to get clarification on where you stand on the many different fronts that we now have opened on the rule of law front. I'm looking at the watch as well. I know that we have until 3:30, but I would say that we do one more round of questions if there are any. So I'm looking at Clara, there are some. So I would take another round of questions, and then I would go to concluding remarks so that you can all go back to your offices. Yes, Dorian first, and then back to Clara. Yeah.
Put it here. Thank you, Sophie. And this is probably a question and a comment to Mr. Bell and Mr. Kaessner. You mentioned that the rule of law report, as well as the enforcement mechanisms, are separate instruments, but there should be a coherence between those. And the rule of law report by the Commission also heavily relies on the judgments by the European Court of Justice. And by now, we have more than 100 judgments over the past 5 years dealing with the rule of law. So the Court of Justice in Luxembourg is fairly certain what the rule of law is, as the rule of law is at the very identity of the common legal order of the EU. So maybe this goes beyond the political, if it's at the very identity of the union's order. This is more of a foundational constitutional language that the court has used in the very conditionality mechanism just of 2022. So in that sense, when we have such a clear indication to independence of the judiciary as a manifestation, as a function of the foundational principle of the rule of law, can we expect suspension of EU funds for systemic breaches of independence of the judiciary anytime soon? About corruption, but in the case of Poland and other states, the systemic issue is the independence of the judiciary, as well as probably others. That's my question. Thank you.
Clara, we do have other questions, right? Yeah, perfect.
And maybe before that, there were some struggles with the microphone, so maybe we can check that they're all on. But yeah, the first question, I'll come around. The first question is asked by Jus van Eersel. Mr. Kaessner underlines the contributions of civil society. In my experiences, there are substantial differences in quality between civil society. About what kind of NGOs are you talking, and how do you select between NGOs concerning their qualitative standing? I guess that's open to everyone. And then we have a second question, which is broader than just the rule of law report, but how of the EU on the international stage regarding the severe rule of law breaches at home.
Thank you. Great questions, by the way. So I don't have to answer them, which is wonderful. Should we start with the question by Stoyan on cuts in EU funding for systemic breaches rather than for very individual and more narrow areas such as corruption? And I guess the question goes to all of you, but maybe we'll start with you, Mr. Bell, as your Commission representative.
Yeah, I will not speculate. I cannot speculate. I can just refer you, as far as necessary, to the conditions for application of the conditionality regulation, which identifies a number of components that are relevant for the assessment as to whether there are sufficient grounds to apply this procedure. And one of these components is a breach of the rule of law, where obviously independence is explicitly mentioned in the regulation as one of the essential components. There's no doubt about that. There is another component, that is that the breach must have a sufficiently directly impact on protection of the budget, and there are more conditions and elements that apply in this regulation, and so judicial is relevant also for the conditionality regulation. This is also clearly confirmed in the two cases of the Court of Justice on the conditionality regulation earlier this year. But then the Commission will have to assess the situation on the ground in all member states, look at the conditions, all the conditions that are relevant under the conditionality regulation before it can make up its mind whether there is sufficient ground procedure. I think I did not tell you anything new, but nevertheless, I thought it was useful to recall this.
Thank you. Anna, I'd like to come to you first with also on that question of whether you see the EU doing that in the future, more on systemic breaches or just on corruption or independence of the judiciary, and also straight ahead also to the question on the credibility of the EU on the international stage, if you have any comments on that.
I would say that I see greater potential in infringement actions, cases before the ECJ, and potential penalty payments ordered by the ECJ in relation to judicial independence, because this is something that has already happened, as it was mentioned. So I think if there will be more cases, more financial penalties can apply. Of course, we are speaking about much smaller sums of money than regarding conditionality mechanism and not approving of the next generation EU national recovery plans. And on the question of the international ear that is listening to what is going on in the EU regarding the rule of law, I think that there is a new point of pressure from the Ukrainian government, at least those governments in the Union that are striving for very good neighborly relations with Ukraine, and not only neighborly, I mean neighborly in the sense of the bloc, would really take into account what they are saying. And I think that if countries such as Poland would like to be advocates of Ukraine's membership or closer cooperation with the EU, they should strive more for upholding EU principles at home. And that is something that should not be overlooked.
Thank you. I know that we still have the question on NGOs, but I don't know if Mr. Kaessner wants to come in on any of the questions that have been asked.
Not so much on NGOs. I think that's for Nicolaas who talks. experience of interdependence between the if the court, what the court said, it's never absolute. Although it is absolutely vital to have this framework for the everything else. On the conditionality, yes, it's independence of the judiciary is explicitly mentioned as a breach of rule of law that can create a risk for the sound financial management. So yes, there's no the door is open, as I say. And third, on the credibility, I think that is one point that is very much picked up, or not picked up, but all governments around the table. Yeah, that if you constantly to the outside, the beacon of freedom and democracy and then values and process, you put so much emphasis on it. It's also clear that once you are in, you have still to make sure that these values are being respected, and that is why basically now you have a very vast majority of government in support of this process, now putting this EU, supporting this EU policy on values, on rule of law, which really wasn't there 5 years ago, 10 years ago. So there's some the right direction. It's definitely one of the absolute key elements in this.
Yeah, I think that's also a very important point to make, that of course, when you try to fight a Russian aggressor in Ukraine that has an authoritarian government, that we do not accept the same kind of thing in Europe. One last point on the NGOs. I think that was a very interesting question on, the quality of NGOs that you're going to include also in the consultation process for the rule of law reports. How do you know that you had also talks with some corporate organizations? So I think there was also some discussion amongst civil society organizations of, how do you choose them and how do you define which ones are experts and which ones aren't?
I think what is an important, let's say, foundation of the rule of law report is that it is based on a variety of sources. So there is no monopoly of sources on which the rule of law report is based. We, as I said before, as part of the preparation, we have an online stakeholder consultation, which is open to everybody. So everybody who has an opinion or something to contribute to the preparation of the rule of law report is invited to. And we received, as I said, over 200 contributions for this year's report. We are not selecting at the gate. We also have interviews in our virtual country visits with stakeholders, also with NGOs. And there we also talk to a variety of NGOs in order to have different views as part of the preparation. But then on the basis of all the information that we have collected, it is the Commission that makes itself a qualitative assessment of the situation of the rule of law in the 4 pillars. And that is, I think, an important element to emphasize. It is a report based on a variety of sources, but in the end, it is a qualitative assessment of the Commission on the situation of the rule of law in the 4 pillars that we identified.
Thank you. I'd like to the concluding round. And I thought about it because normally I always try to find a question that fits for the 3, but it's a bit difficult because we have 2 people, representing the 2 EU institutions and then you. So I'll start with you, Anna. And my question to you would be, looking at the coming month, where would you see the EU's most useful way of going forward to safeguard values and the rule of law, and what would you like to see from the different EU institutions?
So I would like to see that the EU is credible and that it actually enforces the law and is not under enforcing the law, which means that it's not going to agree on something that is below what the law, the case law says. And that's one thing. And the other thing would be support, constant support to civil society. That includes support to independent media, investigative outlets that would uncover irregularities, because the NGOs, they rely heavily on media reports and the work of journalists. So without media freedom and pluralism in a very, very essential sense, we will also not have the contributions from civil society, and we will not have the rule of law reports.
Thank you, Anna. And I'll go to Mr. Bell with a question on where is the Commission going to put its efforts in the coming months, or where do you see also the Commission's, biggest possibility to move forward to make sure that we safeguard human rights, rule of law, and democracy in Europe? I'm going to put it in the big way because, of course, we discussed that systematic breaches are quite important, so we can't look at it just in silos.
Yeah, I think our intention is to continue our efforts to make the best possible use of the different tools and instruments we have at our disposal to promote and to protect the rule of law, to learn from past experiences, and to try to improve these tools step by step as they are evolving tools. But in the end, promoting and upholding the rule of law is a joint responsibility. It is not only on the shoulders of the Commission. It is a responsibility for all EU institutions, for member states, for civil society, for academia, for all of us as citizens. And I think the fact that we are having this discussion today is also a small contribution to that end.
Thank you. And the same question goes to the Council, knowing that, of course, there's 27 member states and they all have their share of responsibility, but where is the Council going to, or what is going to be on the agenda of the Council in the coming month where you think you can really have the biggest impact? And I think I know the response, but maybe not. Thank you. I think that political discussion is really important to have. I mean, political scientists, and I know especially on rule of law, it's a very legal field, and sometimes it's good to have that discussion to realize that, you also have politics that plays into it. And of course, the two should not necessarily you don't have a politicization that is necessarily good, but that you need to have a discussion. I'd like to look at what we have here, because I think that the participants in the room have had a look, but I think just to mention that we did have a graphic recording done by Norma that once look at the discussion we had, and then also the Q&A, which will be available also on the website, and that we will really want to have it. But I think it's quite useful to remember all of the things that we've discussed, because rule of law is a very broad field. There are a lot of instruments in the toolbox. There are different institutions with different ways and mechanisms, to make sure that we safeguard rule of law. So just to mention that we have tried, and I think it was very nice to have that on top. Otherwise, I'd like to say thank you to the speakers to make the time to discuss here. I know that we didn't have that many people in the audience, but we had quite a few online. So that's always a problem when you have hybrid events, that some people do prefer staying in front of their computers. Nevertheless, it was nice to see you in real life. And thank you so much also for showcasing not only the academic perspectives, but also the and the Commission being here to have that discussion. Thanks also to the participants in the room and those online, and especially to the team and Claret for organizing this event, and of course to Reconstitution for making this happen. And I think and I hope that we will have more events together. Do check out Reconstitution if you're interested, because the fellowships are rolling, and you can apply if you want to work on democracy and the rule of law in the EU. On that note, I wish you all a very happy afternoon and a lovely evening.